The murder conviction against Letecia Stauch, the woman accused of murdering her stepson in 2020 and convicted, was thrown out. Today, the State Court of Appeals ruled the trial court made a critical error, allowing a biased juror on that panel. According to the ruling, one juror's son-in-law was a deputy district attorney in El Paso County, the same office that was prosecuting that case.
9 News legal expert Scott Robinson joins us again to talk about this. And I think right off the bat, Kim and I have been baffled by this, and we're not lawyers, we're not in the legal system, we cover these things. How did this get through?
Well, it is an enormous mistake by the judge, and it was compounded by the district attorney's office. They were taking an enormous risk to object to challenge for cause for this individual who didn't express bias, but because of the statute, he was impliedly biased, which means he should not be sitting as a juror. This is really a combination of bad decisions by the judge and the DA, and a risky gamble by the defense lawyer who didn't use all of her peremptory challenges. Those are challenges you can use without having to explain why, unless it's for a racial or ethnic reason. And each lawyer had, in this case, at least 12 peremptory challenges. But it's something that should never have happened in a case this serious.
Is it on them to use that challenge, or can they take a chance and say, hey, we may get an appeal on this?
Well, so far their gamble has paid off. It's important to note that this was a 2-1 decision, and ultimately the Colorado Supreme Court will have the final say as to whether this was grounds for an appeal. But the enormous amount of grief and suffering and expense for a retrial based on this ill-advised decision not to kick off a juror who was by statute not supposed to serve on the jury, that's just inexcusable.
Yeah, I mean, that's the part that I just can't forget. This was the sweet young boy that was murdered, and that testimony was brutal to listen to, and I think you'd have to do a trial again. So this will go to the state Supreme Court for sure?
Well, they'll ask for review. It's called certiorari. It's discretionary. Less than 5% of cases that are before the court are actually accepted. But because it's a dissenting opinion, and the judge who dissented was the longtime Adams County prosecutor and then a judge on the Court of Appeals and the chief judge, I suspect his dissent may be enough to tip the scales so that the Supreme Court decides once and for all if you have to exhaust your peremptory challenges to claim prejudice for a erroneous denial of a challenge for cause.
Do you think defense needs to be concerned in any way about the retrial? What happens in a retrial?
Well, on a retrial, actually nobody wins. It's an enormous expense. The defense will have already taken their best efforts at defending the defendant. The prosecution will already have done their best. They'll have literally thousands of pages of transcripts to work on. I mean, the amount of work that will be required on a retrial is massive. But we have a system where you're supposed to make sure that the jury is legal and unbiased, and that people who shouldn't be on the jury aren't on the jury. And this is unfortunately the price that may be paid in this particular case.
Yeah, I mean, both sides have seen what each other's got for a trial like this, but I look at this and like in a dumbed down version of this. I mean, everybody talks about serving on a jury and why, you know, you have to tell everybody why you might be. But when you're telling somebody that, I mean, I'm not a rocket scientist, but if I'm either one, prosecutor or defense attorney, I'm like, you're out.
Yeah.
I mean, just like that would be a no-brainer to me.
It should have been an easy decision. The initial fault lies with the judge, who should have known better that this individual was statutorily prohibited from being on this jury. And then the DA, in insisting that the judge question the juror for bias, even though that's not what the law requires. Again, you can fault literally both the judge and the prosecutor, and depending on how the case comes out, might be in a position to fault the defense attorney if it turns out the Supreme Court reverses and holds that that the peremptory challenges were not exhausted, and so you can't claim that you had an unfair trial.
That's the gamble you're talking about.
That's the gamble.
All right.
That's the gamble.
Thank you so much for breaking this down.
Sure.
Appreciate it.
Thank you, Scott.